I can't, it ain't working. This is hardcore right
Today
here.
I need you when we get done here, so we can go over what I need, what the testimony would be if you were asked a few questions.
All right, I'll go at halftime to the game then. I know, right?
Neither are we.
It is their opening, it's their opening game Thursday night. It's their opening game Thursday night. My brother and I, we get season tickets. That's one thing we do together every year. Me and my brother go to all the UW. That's our one thing that we do. He is. I put 2 kids and 2 wives through college. I don't even have a degree. How do we do that? You know, we.
Prior to this.
That just means we're doing something right.
Means something.
Exactly.
So you're not gonna hear me tomorrow night.
We're hitting some nerves.
That's something interesting. The man just simply. Yeah, it should be. Yeah. He don't like that we didn't stick it to him, but we couldn't. He's got last year.
Unless you dig it out.
Well, I mean, not in the pictures, I'm saying from what I'm hearing from other people.
Oh, no, 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 no.
Cost,
Right, right, right. No, in the grand scheme, no, and the size of the house, it was not that. Yeah, cause
What
the
I'm
house
hearing
was
these
3,000
days is
square
just
feet.
ridiculous.
Yeah.
I'm hearing
Yeah, so there's certain roofers. They'll charge 40 grand for it. Yeah, I mean, it's just, yeah.
Call this meeting to order. Call this meeting to order. Escambia County COMSI Board for our September 4th meeting. Madam Secretary, do you have a determination of quorum with a full board?
We have a full board today, all members present.
I'm so thankful we don't have any quitters up here. Do we, do we have a proof of publication?
Yes, sir, Mr. Chairman. It was published on August 29th, 2024 in the Escambia County Sun Press.
Good deal. Do I have a motion for the approval of minutes from the August 7th meeting?
So moved.
Do I have a second?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved. Madam Secretary, do we have anyone for public forum?
I do have some speaker request forms. Our first one is Mr. Lin Yang Lee. Mr. Lee, if you'll come to the podium, state your name and address for the record, and then you can address the board.
Okay. My name is Lin Yang Li. My address will be 1029 Black Walnut Trail, Pensacola, Florida, 32514. The case about the my train is almost like 5 years ago, and the last year, before you guys make a decision, and cancel his license. We make on the other the court with my lawyer and his lawyer will make the settlement agreement. It was he owed me like $144,000. Finally we make the deal is around like $100,000 the final, and the start payment is like a $5,000 begin, and every month like $2,000, and he pay me only like 7 months, so he only pay me like 19,000. He still owe me like $81,000 for everything, but he should be pay me on the last month, August 19. I gave him almost like 1 year, but finally he didn't follow the agreement, and that's why I come back here. Want to you guys maybe the rehearing, reopen the case. And also on the courthouse, I will be follow my lawyer and will be reopen the case and rehearing, and maybe begin the claim the money. Only one, that's what's happened. It's take too long because this case, and I lost my marriage. I divorced last year, because this one. She know it's before it's my actual wife with me and follow the case, rather only myself. Yeah, it's really hard time. I almost broke last year end, Yeah, for real. I borrowed money from my mom, It's really hard. And I divorced last year just after this case, It's because she don't want to raise me broken. And that's what's happening right now. So I hope you guys maybe can stop his license until he pay me back. That's all I want to do, because I'm nothing to lose. He's fine. He's really good, Yeah, and I give him a lot of chance, You got the punch time to pay me. I give you almost 1 year, but right now still like that, and I don't want to talk to him anymore, like unofficially, And we make agreement. I already reduced the price from like 144,000. I cut almost like 1/3, right? Yeah, but he still didn't follow the rule. He didn't follow the agreement, and I'm really despair, Yeah, so I hope, that's it, I think.
Mr. Lee, could you tell us who the contractor was again?
My tree, this guy. Yeah, his name is HM, the contractor. Yeah, the case about my restaurant before.
Right.
Yeah, but I don't have a restaurant anymore. Yeah, and
And so it's still owed a balance of 80-something thousand.
yeah, $81,000. Yeah, but before the agreement is the 144. I reduce make agreement before you guys cancel his license. I say it's okay. He pay me, it's fine. I don't want he lost the job, But until now, I'm nothing to lose, so I'm okay. So you can just cancel his license until he pay me back. Yeah, I'm really poor guy, I think. Yeah, just because this case, and this case is last year on the August, right? I divorced September, send the paperwork on the November. So I'm nothing to lose, I'm okay. You want to go to the courthouse, I can go to the courthouse, I can sue you in the end. I'm done, I'm done for this guy. I'm really done for this guy. I'm really tired. It's 5 years since the restaurant began, the job. You can see what time I sue him. It's take too long. It's all my life money inside. I sold house in China. I sold my house local. It's crazy. Yeah. Finally, this restaurant is it's gone. I already sold the restaurant. It's lose the money a lot. Yeah.
Question, Christophe.
Go ahead.
What jurisdiction do we have here?
That's what I was going to ask Ms. Christie.
Just talking to Jennifer about, I believe what the board did was put him on probation. I don't know that there was an order as far as restitution, because there was the secret, settlement. And if he hasn't fulfilled that settlement, I believe he's going to have to go back to the civil court system and see if he can get enforcement. But Jennifer's pulling up the order now, but as far as jurisdiction over it, it would have to be a new case with new facts, because you've already resolved your issue, your case.
So he does have the option of coming back through Ms. Reber and
Only if there was a new case, like new facts. The fact that he didn't pay the money on a civil case isn't something
That's
that you can
nothing for
look at.
us.
So the court would have to do that. He says he has an attorney and his attorney should be addressing, but we're double checking the order at the time.
Did we put him on probation, or did we, if we put him on probation, are we not allowed to go back?
So what you have in front of you now is the final order. And originally, restitution was ordered in the amount of $140,000. They came, after that, they came to a settlement agreement and
the
brought
civil
that to the
case.
board. He was put on probation for a year. And
If you look at number 3, scroll up just a tad if you don't mind. Restitution is ordered. The board reserves jurisdiction for additional restitution in the extent local, state, and federal law allows. Restitution shall be paid within 90 days. If respondent should fail to make restitution payment in full within the required time period, the respondent shall be brought before the board for further disciplinary action. Does this allow?
This order was entered on May 4th, 2022.
3?
Say 23?
23.
Okay, so we're outside of that probation. It was just for a year. So we're outside of that. And as explained, I believe they came back with information about the civil settlement.
Right.
So once we got past that year mark, once the probation went away, he was no longer he didn't pay it within the 90 days, but that was forgiven at the time.
Did we put a stipulation for a year? Because I read concurrently.
I didn't see that on there.
It says probation to run concurrently.
We did probation on
right
each
down to-
count, and then it was 1 year per count. That's what ran concurrently, was the probation from each
Okay,
count.
understood.
So as far as, I can't remember what happened, but I do recall that at the 90 days, of course, he hadn't paid it, and there was a civil settlement involved. So we didn't go any further with it and enforce the 90 days at the request. At the time, I believe it was the request of the complainant, that this be resolved within through the civil court system.
So we are limited without
So we're without jurisdiction.
jurisdiction at
It
this
would have to
point
be a new
here
factual
unless
basis.
there's new information that comes out. And that would have to be something more than he did not pay the payments?
Right. He didn't make the payments on the civil settlement. Although we had the restitution, we only set it up for a year. We required him to pay within 90 days. When he didn't pay within the 90 days, we're double checking, but I don't think there was no action taken. We can look further and see if there's a failure to satisfy a judgment, but that would be a new case. Okay? But as far as the old case, I believe it's gone. It would have to be a new charge altogether. So we can look into that and give you better information. But as far as enforcing it, we can't, other than putting restrictions on the license or permitting, it's actually the civil court that can enforce it with greater, they have a lot more power than you do.
Through a judgment or something of that nature.
Right, and possible, they have more enforcement options than you do. Although yours can stop everything. Yours can stop all permitting, so.
We have certain guidelines that we have to operate in,
Yeah, I understand.
and sometimes it doesn't seem fair. I do understand that, but we're still limited to those guidelines.
Okay.
And from what our legal is telling us, as you heard, we're pretty much maxed on our part unless there's something new that comes out with his behavior, not just the money deal, with the construction.
Yeah, I know he have the other case also, so. So what should I do right now?
So at this point, and I would suggest, and we'll check with council to make sure, but I would suggest that you follow up with our staff just to make sure that this is correct. But at this point, the civil side is going to be your avenue.
So there is a requirement, for failure to there is a code for failure to satisfy a civil judgment obtained against the licensee or the business organization. So right now, he has a civil settlement. We'd have to see the case to see if he actually has a civil judgment. So at this point, we're just going to have to look at this more. This is,
Is it fair to say that he should talk with staff and try to determine if there is, in fact, a path forward?
right, and we'll have to look and see where we are with the
Okay.
judgment, because the settlement was confidential, so we couldn't see it
Right,
at the
right.
time.
Mr. Lee, you understand the route at this point would be to get with staff, Ms. Melissa, Ms. Jennifer, and see where your civil case is. Does that open a door for us or not? If it does, we'll be glad to hear it, but we don't know that until there's more research done.
Okay, just let me know later. It's
Well,
okay.
at this point, get in touch with, both with staff and also talk to your attorney. Okay?
Okay,
All right?
all right, thank you.
Thank you, Mr. Lee.
Can we take a few seconds and listen to the contractor? No, you can sit down.
Okay.
Does he have any intent? Oh, it's not open. Okay,
This
I
is
got you.
public
Public
forum.
forum.
Okay, gotcha, understood.
Do we have anybody else?
Yes, sir, we do. We have a Thao Brewer. Ms. Brewer, if you could please come to the podium, state your name and address for the record.
Hi, my name is Tao Brewer, and my daughter Ginger Farias.
Your address.
Our address, 4048 Ashland Avenue, Pensacola, Florida, 32534. And what else?
My name's Ginger Farias, and my address is 4029 Ashland Avenue, Pensacola, Florida, 32534.
Thank you.
Go ahead.
Okay, so this is the two different cases. The first one is, the address is 945 East 10 Mile Road. Mr. Trung, he's built it for me, and last time when we was over here, I guess maybe he's supposed to come back and finish the job, but he just let it go, and I call him many times, he don't answer, so I texted him, and you know, he answered a couple of times whenever he need, but the answer is yes, no, and at first I asked him, I said, can you please just come back and finish whatever we have to finish? He don't respond to that. And then finally, I text him again. I said, can you please just bring back the keys for the lock that he put in? He only give me one key for the temporary doors in the front, and all the rest of it, I don't have no keys. I tell him, please bring back the keys, give me the screen for the windows, and the shutters for the hurricane shutter. He don't respond to that. I keep texting him, he don't respond to that. And then I tell him, I said, you know, I'm your friends, I'm not your enemy. Please come back and do all this thing for me. And still, he don't answer. So the thing that I just paid for water bills, he turned on the water with the ECUA 2020. What is the date?
2020 and till May, he didn't pay the bill, so they turned off the water, then somebody else turned it on, I don't know from the road or how they did it. So in order for her to turn the water on in her name, she had to pay his bill from 2020 in order to have the water turned on.
Yeah, so I have to pay $288 and so many cents for me to turn on the water. So many things broken in there in the house. I don't know how he have the CO when the air conditioner doesn't work. I keep asking, call him back again, please come back here. Please send somebody to see what's wrong with it. And still he don't respond and he don't do it.
So we had to hire other people to come in and finish
Yes.
all this other work that needed to be done.
And so many things happen. All the tiles is broken, most of them broken, or the one that not broken is gonna lose. The bricks is all messed up. I keep asking him. He said, "Oh, don't worry about it. I go wash it off." Now you cannot wash it off because everything is all stained.
The ceiling fans didn't work. We had to hire someone
Yes.
else, an electrician, to come in and install new fans that we had to buy. All the door locks we bought over again because we didn't have the keys for. Like she said, there's no screens in any of the windows, and we haven't, we need that, the key.
And window is off track. And I told
Yeah.
him to, and he went over there, he take a look at that, and he see that. And, whenever you can even lock
Windows
the
won't lock.
windows. Yeah, and, when the window is shaking. And when you go over there and it's not, on the top is wide open, and underneath is like this, yeah.
Yeah.
So that's why the window, all of them.
No shelving in any of the closets. We had to purchase that and install that. There was no bathroom hardware in any of the bathrooms. No
mirrors.
mirrors in any of the bathrooms. The concrete driveway that they had to re-pour because it didn't pass inspection and they had to redo it. They took all of the old concrete, which is a lot of concrete. It was a big driveway, put it on the property next door, which is also our property, the 930, and never cleaned it up. And for us to get somebody in there, it's going to be costly because it's such a large amount of concrete to be disposed of.
And another thing that's, when he redo this driveway, I went over there and I see they poured a new driveway. I say, please come back and see, this is all the rain come and they wash off the dirt and everything. I say, look at that, look at the hole. I show it to him. I say, look at the hole. If you don't put the sod on there, or maybe you don't fill up the dirt or something, it will be cracked again. He just ignored it. And then later on now, the driveway is big crack on the driveway. I'm very upset with him because he don't respond. He don't want to, he don't respond. He don't want to talk. He don't want to, nothing, So I feel just like I trusted him. And this house is my dream house. I'm 75 years old. I cannot build any more. And I thought this is a house that I can move in and live in there. Now, for somebody to come and fix the thing that the painting in the house is messed up, the caulk and everything. He don't even caulk the house, he don't even paint it. And I called somebody come to give me an estimate. It cost me from $41,000 to $48,000 to fix all that. I don't have the kind of money to fix. And I begging him, I text him all the time. I said, please come back because I'm not your enemy. I just want you to finish. And if you don't want to finish, then give me the thing that I asked you to, the screen, the hurricane shutter, and the keys. I end up have to buy all the new lock for the keys because I have no keys to get in, And I have to buy the front doors because he has a temporary doors. So I have to buy the front door to put it in, and I have to hire somebody to do that. So right now I just do slowly, little by little, until
Right.
when I can completely finish. So please
Yep.
help me.
We had a case on this, if I'm not mistaken,
Yes.
and it was
That is
agreed
correct.
that he was going to finish it within so many days or something?
That is correct. So we did have a case, and as you can see, I brought up the final order for that. He was fined, and his permitting privileges were suspended for a year from the date of the final order. So his permitting privileges are currently suspended. The board at that time did talk about that if he were to finish out Ms. Brewer's house and then close out any active permitting, then you might consider allowing his permitting privileges to be restored. He would have to come back to the board and request that. I think the gist of what Ms. Brewer is saying is that during him finishing up her job, there were some things that were not done correctly. Okay, I got another one.
And I'm sorry you're having to go through this,
No.
Ms. Brewer, but the last week, this is the first we're hearing back of it, and thank you for coming to bring it to us, but the last we had heard, there was a time frame for him to get finished, et cetera, as Ms. Jennifer mentioned, and now that we have new evidence, I would believe that you could talk to Ms. Reber and Ms. Hampton and reopen a new case based on new evidence.
Yeah.
Because this is something new from the previous time. Am I saying it right, Miss Legal?
That's what we were just discussing. I believe what you're telling, what I've heard today is new facts.
New facts, right.
And at the time, I think he still had a permit open on the property. So this would be new facts under the same permit. So that's what we were just looking at to see, according to the final order, is it something, because you did retain jurisdiction to enforce the order, but these are new facts, so you could have a new case.
So I would suggest, again, sorry you're having to go through this. That's what we deal with. But if you'll talk to these ladies, they will be happy to reestablish a case here, and then we can go forward from there.
Yeah, like I say, you know, this is my last house, I cannot build anymore. And, you know, for that kind of money that I have to fix, I don't have that kind of money to fix it.
I understand.
40-something thousand. So I just ask the board to please help me. You know, I know that he not gonna pay me any money back or anything like that, but at least, you know, maybe take his license away or something, because he acting like very arrogant, you know, whenever, if I ask him something that may be benefits for him, then he say, yes, no. That's the only one word I hear from him, but the rest of them, if I ask him, can you please give me back the things, or he don't answer, don't respond, so arrogant, you know, so I feel like if he still continue to have license to work on somebody else, he would do the same thing, just like what he did to me, and it's not fair. I don't know how he get the CO after when the CO, the garage is leak underneath, and I don't know how he get it. The air conditioner doesn't work. How he get the CO, and another thing, you know. I have to call somebody. I have to tell the plumber, please come and help me, and I pay for you. I call his own plumber. I said, you know, please come and help me and work on that the leak underneath the garage. So he did come. He didn't charge me for it, but. You know.
And some of those items perhaps would be warranty items, and there's different levels here, and we would be able to do more research and find out, is that something that is, I use the word warranty item, you know, something that is not a structural defect that would be versus a cosmetic type thing, but it still needs attention. I'm not minimizing it, but that will help us determine what level of intensity that we would pursue after.
Yeah.
So I would definitely suggest that you get with Ms. Jennifer, Ms. Melissa, and let's see if we go forward with this,
Yes,
okay?
I will. Thank you so much. And now
Thank
this
you.
is the second case that I paid him $10,000 deposit because he built a house for my nephew.
Yeah, I remember you telling us for the
Yes,
next house, yeah.
Yes, so I give him $10,000 just to hold for the price. Because I
Right.
told him, I said, I like that house that he
Right.
built. He said, I can build it for you, the same price that he built for my nephew. And in order for me to do that, I have to put out $10,000 to give him to hold
Right.
the price.
Right,
He didn't do anything with that, nothing at all. On top of that, he threw all the old concrete over to that lot.
yeah, it's what your daughter said, yeah.
Yeah.
And I think some of those things would be civil that would have to go before, that's, you know, again, if
You can
you
do-
reach a hold of them, they will instruct you the right way for
Okay.
this particular case.
Yeah, I went to see a lawyer, which I have to spend money on that, and I
Yeah.
cannot continue to pay the lawyer.
Right.
The lawyer sent him letters, he don't respond it, and the letter come back, and they send again second time, the letter come back, I mean, you know. So I don't know what else to do. The attorney said that if you want to continue to do that, then you have to put out the retainer fee. I already put, you know,
Right.
money on that. I don't want to spend more money when I don't know
Right.
what he can do for me.
Well, they can help you. If you'll get in touch with them,
Yeah.
they'll be glad to help you, and we'll see if we can make it go forward here.
Okay.
Thank you so
Thank-
much. Thank you
so
for
much.
coming.
Thank
Yes,
you.
ma'am.
Chairman Lister, Mytran did fill out a speaker request form, so he does have, so he can speak. If
The
he had not
builder?
filled out a form, then he, you know,
Okay.
he'd been restricted, but he did fill out a form, so if he wants to speak, he can.
He is the actual next form. Mr. Tran, if you'll come to the podium, state your name and address for the record.
Hey, Mytran, 1161 West 91 Half Mile Road, Pensacola, Florida, 32534. Concerning Ms. Brewer, best way in my is get a third party home inspection. But I don't want her to choose it. I'm not gonna choose it. But choose a home inspection, I will fix whatever on the home inspection. I did my best to get a CO. I did everything structural. But when a water leak, I found a water leak. I'm the one that called the plumber out. And he came out and fixed several spots. And I didn't know he charged her because she also communicated with my plumber. So he never sent me a bill. But I told him, you have a leak in the garage. And he did came out. And the air conditioner is working now. I mean, I did send the air conditioner guy come out and look and fix it. It has been fixed. But to resolve, just get a home inspection. Whatever list on there, I fix it. But cosmetic or whatever, otherwise, I cannot control that. But structural, anything, structural, I will fix. So home inspection, we'll have a report, and I fix what on the home inspection report. And concerning why I'm coming here today is Let Meat Barbecue. So I stopped making payment to him when my privilege was suspended. I need to work to keep on paying, and that's why I'm here today, is to ask temporary, lifting for my 2 permit so I can have income and continue paying. Without working, I don't have the funding to pay. That's why I'm here today. I'm not hiding from my settlement agreement. It's just I'm in a tight spot. I'm not working. And I want to make it right.
We're not in a hearing, so you can't reach any decisions.
we can't do anything with this, Mr. Trainer. You may have picked a bad day since you have 2 people here not saying good
Yeah,
things
I understand.
about you. But
I didn't
you would have
expect
to go
that.
back and speak with staff and try to get back through that. I'm not sure there's an appetite much for people who ain't paying their
So,
fees.
so how this would occur is, if he's requesting to have those privileges reinstated by the board, he would come to the board during public forum, and then board, if you were amenable to that request, you would direct staff to bring it to you as a hearing. It's up to the board whether or not you want to direct us to bring it to you as a hearing, like you just stated.
Is there anybody on the board that would like to comment?
I think I just have a question on this, as far as timeline here. Because I believe the date was 2024, whenever his license was suspended. However, and that was with one case. And then with the other case, that has been ongoing since 2022, 2020.
So the first case originally began in 2022. It came
Okay.
to a final order in May of 2023,
Okay.
which included a year's probation.
Okay.
Then we had the other case, and its final order was in April of 2024, which would put him April of 2025 before he could permit again.
Okay.
Yeah.
So with that, he has not paid the full restitution or the settlement or fully for the first case. So that really wouldn't have anything to do with him having had suspension on his permits because he still had all that time to pay said first case.
So these are all things that if you were going to do a hearing, that would be a discussion and a question that we would resolve at that time. But during public forum, because the public hasn't been noticed that this is coming before the board, we can't really discuss it at this point. But I think your logic is following. But we'd have to have the board, and it may come up before the board again if the facts that come from the 2 people that have been before you today, when it's looked at again, that may be the best time, or you and I can talk later, or you can
Okay.
talk to Jennifer. But as far as discussing it,
Right.
to make,
I just wanted to make sure the timeline, I was correct in that.
Right, you're seeing the
Okay.
dates correctly.
Okay.
Yeah.
And then two-part. So he had admitted that he called out contractors and he was supposed to pay it. However, Ms. Brewer paid it. So would that mean that there would be a potential restitution? Obviously, not to talk in public forum, but that would come up in the new case of facts.
Those are things that would have been addressed in the new investigation.
Okay, perfect.
Thank you.
Thank you.
So does anybody have any comment about the option of reinstating license, given the current situation?
Do you have any other permits open right now, or those are the only two, or one?
We pulled a report yesterday whenever Mr. Tran notified us that he would be coming to public forum in hopes of having his permitting privileges reinstated. There are some historical permits that are open. We didn't go through and look at what items were outstanding, but yes, there were some permits that are open.
And he could still work on and close those.
That was the direction of the board during his
right.
disciplinary hearing, was that he could work and complete any finish any open.
So he has had
projects.
opportunity to work on jobs and obtain money to pay these fines. Sorry for being so blunt, but that's the fact, right?
Well, that would have to be determined in a hearing.
Based on the fact that the permits are still open, and we allowed for him to still work on those permits.
Right, but we don't know, as far as discussing the facts of
Right,
those
right, right,
permits,
right, right.
we can't do that
No, I
until there's.
understand. I'm just
I know-
trying to-
I get what you're kind of talking, putting it out there. I understand. We just have to be careful because we haven't done
Make
public
sure the
notice.
board's aware of what's. So, do we need to have a motion for this, or do we just need to not?
So if you are amenable to that idea or to the request, then you would just give direction. There is no motion involved. It's up to the board whether you give direction or not.
So how do I get a consensus from these guys, ladies?
You can just make that determination by yourself.
Oh,
You can ask for a motion, if nobody gives one, you have your answer.
Yeah, concerning on the open permit, those might be open permit that I haven't closed back then. It's like,
And
Mr. Chair-
that's again something that if
Yeah,
it were brought
we-
before the board for a proper hearing, then he could discuss that. But at this point,
Can I do
my
a s-
recommendation would be let the department do their investigations and see if they're gonna do anything with the other two cases, and then it will be back in front of you, and you can explore lots of information.
so is it legal for us to do a straw vote at this point to see a consensus of where, because I know what I'm feeling, but am I the only guy up here feeling this? You know what I'm saying?
It would still have to be noticed to the public whether or not you're gonna rehear his
But whether or
position.
not we even hear it.
I would go with your feeling.
Okay, my gut.
Yes.
My gut is that we need to hear these other cases before we do anything with you, Mr. Tran. We gave you, this is not your first time in here. Now, we're nice guys, we really are, but we know how to be firm when we have to be. And we can't base today off of any previous cases. We do case by case. But you're coming and asking us for something whenever we have, even today, 2 more cases that may very well be reopened. And there's just no appetite here.
yeah.
Since you have already had an opportunity to make these payments, you chose to not make these payments. When you made that choice, you kind of made a statement to us.
I couldn't afford to make
Well,
a payment. I went through and closed out what I had open and work, and I closed out for, I think all them closed out CO for 2 or 3 months. Then I come back.
I'm not a wise man, but I'm
Yeah.
not a dummy. I live about a half a block away from that.
Yeah.
There's a statement that says, desire finds a way, lack of desire finds an excuse. Might want to think on that. I think at this point, we're not going forward with changing your status. We will hear these cases, and we will go from there to see if there's anything. And at that point, this board, unless somebody just totally vetoes me right now, we will not be extending your privileges right now at all.
Okay. And so I see you next month?
We'll have to go through that. You'll be served notice if there's anything that comes out of it.
Okay.
You will be served notice.
Okay, thank you.
Thank you, Ms. Tran. Didn't mean to get philosophical there.
It's good, we're all gonna use it. We're gonna use that.
It wasn't my original, but it's been good for me for years.
I know, I'm not sure that you can see it, but the first speaker, Lin Yang Li, is that correct? He's raising his hand, and I'm not sure.
Are we allowed to have somebody come back at public forum and re-speak?
It's up to the board. He did sign up, so if you want to hear from him, as long as, like I said, we need to avoid the
Mr. Lee, I can
facts.
tell you this, if this is about your case, then you still need to talk to Ms. Melissa and Ms. Jennifer. So you're welcome to speak to us, but if this is just going to be,
Because I just heard his reason, but when he talked to my lawyer, it's the
I
other
got
way.
you.
He say he don't have permit to make money to pay me, right? But when he talked to my lawyer, say I'm ready to meet my claim. This money payment should be sent for sold the house. But unfortunately, last week the buyer quit, so he found a new buyer to buy this property. Will be finished on 45 days. And I will be, I know will be disappear for this payment, but he should be find the new buyer and pay you the last money. That's he give me the reason by the lawyer.
so I would
So-
definitely suggest you get with Ms. Melissa and Ms. Jennifer,
Yeah,
and let's
yeah.
see about going forward with this, okay?
Yeah. Just do you know it's a different reason? Let me really.
I understand.
I'm sorry about that. But,
No, thank you, Mr. Lee. Thank you. Sorry for your problems you had to go through. Okay, anybody else for the public forum?
We do have one more speaker request form, Julie Ricks. Ms. Ricks, if you'll come to the podium, state your name and address for the record, please.
Good morning. Julie Ricks, 215 Berry Road, Pensacola, Florida, 32507. So this is not where I want to be today. I just want to let y'all know this. I moved here 5 months ago, and I found a property that I wanted to purchase, and I did. And I went to look for a contractor. And on the advice of my realtor, she knew of a couple of sites that were on Facebook, one being the Pensacola contractor site. So I posted, and I received 40 or 50 responses from different trades. And not knowing exactly how it works here, because I'm from Virginia, it's a little bit different. I tried to trust the process that people would be honest. Right? So I met with a particular contractor at the property before the house had actually closed. And he said, oh, I can do this, oh, I can do this. Let's come back, I'll send you a contract with, you know, how much I think I can do it for.
I'm sorry. I'm sorry. I have to interrupt you. This is a case that's currently under investigation so I just want to give you a heads up that this could have influence on your decision coming up.
Okay.
And it's a case that I know that they're currently looking at. So just be careful in your response and in the facts that she lays out, because you don't want to become influenced at this point.
Thank you.
Well,
Okay.
Isn't it in the instructions that we cannot have discussion in this setup in case it may be coming up, or is that just for the day?
If you could give me a moment, I'll look that up
Thank
for
you.
you.
Sorry, Ms. Ricks, we didn't know that that you've already started a case with this. We
Yes.
didn't know that. I'm
Yes.
sorry. We did not know
because
that.
I thought I was allowed to speak.
You are. Every citizen is allowed to speak at public forum.
Okay.
But what county legal was doing was making them aware that it is a current active investigation.
Okay. Okay.
Because
But is it? Is it actually going to go forward? Because I was under the assumption that it may not, because,
It's still under investigation at this point.
okay, okay, okay. Okay, so can I speak now or no?
Can you give us just a second so that Ms. Christie can?
Okay, sure.
We don't mean to be disrespectful to you at all.
No,
We
not
want to
at
hear
all,
you,
not
but
at all.
we want to make sure that we're processing it in the right vein when
Okay.
we hear it.
Okay.
Maybe some of this cooler weather we're fixing to have you brought from Virginia to us. Is that correct?
Nah, I don't
We'd
know
like to
about
believe that at least. We'll get it for about a week and then we'll get summer again.
Yeah.
Did you get that on record?
Not unless you call recess. But, Mr. Chair, I don't think the instructions were read prior to the public forum, which the instructions say not to bring up any case.
Yeah, yeah.
That's what, I don't think that was espoused.
Thank you, Mr. Bell.
It's not on the public, it's not on public forum, instruction.
So,
We'll be here again next month.
Right.
we just want to make sure that we're not slanted by anything that's said today when a case actually comes in. If a case, in fact, comes in.
Exactly.
So, Ms. Ricks, what was your intent today for a public forum? Just in,
No, that's okay. So here's the thing with public forum, it is wide open. There's pretty much, we can't restrict content.
Right.
As you're aware. I just want to make the board aware that this is a pending case and that the facts that she may be presenting, I would not encourage you to ask questions or to take it, understanding that no notice has been given to the other party. And you'll have to, and if it influences your ability going forward, then you'll have to disclose that. Your ability to be impartial going forward, you'll have to disclose that. But
Okay.
so most important is to let you know that there is an investigation pending. You cannot direct, you wouldn't direct the investigators to do anything about the case in this situation because it's already being
Sorry
reviewed.
to start.
Okay?
Everybody aware of that now?
Yeah, Mr. Chairman, I don't think public forum requires a board response. It's, I think we're required to listen. is
To
what I
listen.
understand. Yes.
Thank you,
Just
Mr.
remind all the board members.
I appreciate that. I appreciate you being here and reminding us of those things and staying with us.
Sorry, ma'am, you can, sorry to interrupt you. I just wanted to make sure the
That's
board was
okay,
properly
that's
instructed.
okay. I mean, look, I can actually just sum it up then. I don't even have to bring anything forward about what's happening with my case.
Okay.
But I will ask a question, and I think it's a question that anyone that is a citizen should be able to ask. are you allowed to perform work without a permit?
I would recommend that you not give any advice. This is something that needs to go to the building department.
My advice was, there's a gentleman over there that's like the walking Bible on those things.
Okay,
And,
so I would ask him, okay,
Touche.
so I can't ask them anything.
Right, this is public forum. This is your opportunity to bring anything to their attention that you want to bring. It's certainly, you can ask them questions, but they have no duty to respond at public
Okay,
forum.
But anything that I bring is possibly pertaining to my case.
And you're welcome. It's public forum. You can talk about it. They just have to understand it in context, that there's a pending investigation and that they can't use the facts that you're bringing today. It cannot influence their decision. It can influence their decision should there be a finding and a hearing.
Okay.
And if it
Well, I
does
mean,
influence,
If I don't, like,
you can put it out there.
it really needs to be put out there.
You
I
can put it
feel
out
like
there.
does.
and I can tell you this, there's some things that do require permits, some things that do not require permits. That, I know that's
Correct.
broad. And
The way I
Mr.
understand
Tim,
it's structural.
Mr.
structural
Tim and
things.
the building department can verify
Right.
where that line is on certain items.
Okay, okay.
They can be happy to do that part.
But we just want to make sure you understand, you're not being restricted from talking to them.
Okay.
They just have to understand the context.
Okay.
And
okay.
how
I
they
don't
can
wanna
apply
get
it.
them in trouble either, you know?
Well, we want them to be the board that hears it if it becomes, and if they
Right.
become, we just got to make sure they understand and they have the correct mindset when they listen.
Okay. Okay.
Go ahead.
Um,
Sorry.
Okay, so, well, I hired this person just to get to it. I hired this person, and this person told me that in the contract, which I did not sign the contract because we had a verbal contract, and when I got the printed contract, they weren't the same. And so we never really addressed that, except I felt like we had the verbal and I was okay with that. So I was okay to move forward with that. And hindsight's 20/20 now, looking back on it, I mean, I gave him the money, so it doesn't matter. I entered into a contract with this man. But I gave him $35,000 of a $66,000 job. And I've had to chase my money. I have had to pay subcontractors. And I have not, the money that I gave him was not used to pay for the materials. And even since I sent him a termination letter and asked for an accounting of the funds, he has still yet charged more materials to my address with my name attached. To me, that's criminal. To me, this person has taken my money. He just, I don't know if y'all know the word, ghosted. He ghosted me, and it was just, the way I can see it now, because I think I'm following this is a pattern. Because I posted on Pensacola Contractors, I went back in there, and I blasted this guy. And I said, if you have had any kind of issue, this is my experience, it was completely unemotional, just the facts, please reach out to me. The amount of people, I had over 140 responses to that, and multiple messages, and all these people, and I'm like, where have you been the last 3 years to not have made a complaint against this person? Because he has systemically gone through and done this to multiple people. This is a problem. And I heard this lady speaking earlier about she's 75 years old and not having the finances. Well, I'm 57, but I shouldn't have to dig down and spend my money to go get my money so that I can finish my project. This is crazy. So the person is in the room. I don't know if I'm allowed to say that or not. He's here today. His name is Lee Hunter Construction. And I know he's going to sit in front of you in a little bit. And yeah, I had something thought process about that coming in here today. I came last month and I sat back there and I didn't say anything, knowing all of this going on. And I'm a praying woman, and that's why I'm here today, because this needs to be told. This man does not need the opportunity to do this to anyone else. And that's pretty much why I'm here. So that's it. That's all I really needed to say.
Thank you
your
for
time. I
addressing
appreciate
us.
it.
Yes, ma'am.
Sorry for interrupting.
That's okay. That's okay.
Thank you for coming in.
Okay, is there anybody else for the public forum?
No, sir.
Okay. Do you have a status report for us, Madam Secretary?
Well, yeah. So as we know, September 30th is coming up. We have 4 board members who terms are set to expire on the 30th. Ms. Mary Jordan, Mr. Randy Oglesby, Mr. Nash Patel, and Mr. Brian Bell. Three
So glad
members.
they're coming back.
3 members have decided that they are seeking reappointment. Mr. Oglesby has declined reappointment, so this will be Mr. Oglesby's last meeting. He's moving on to brighter ventures.
There's nothing brighter than
So we will definitely miss Mr. Randy. He's been a great board member for us.
Can we ask publicly, is there anything we can do to persuade you to stay with us? We value, you've seen today how much input and how, your wisdom is, your mic's on.
No, I don't think you can change my mind today.
But that's it. Oh, and we
But
do.
thank you.
Thank you. We do have a case that is going before the BCC. I believe Christy got with the chair and the vice chair this morning, just to remind them that that's going to be going before the commissioners tomorrow evening. That's all.
Well, does any board member want to make a comment towards Mr. Randy in a positive way?
I've been on this board for how many years now? It's been 2 or 3?
You're coming up on, you've done 1 term, so that's 3 years.
Okay. Time flies. Yeah, it does, but at the same time, time flies. So we appreciate everything that you've done for the board. It's been a pleasure sitting on here, having all of you guys by my side and, learning a lot of things about how to conduct ourselves, because I'm usually a talker. And I started listening when I got around you guys, which is a good thing. So we appreciate everything you've done. Thank you.
Thanks, Nash. I would like to commend a couple of board members today. That's Mr. Brian, I think, how long have you been on the board?
I have no idea.
15? I think it's 15 years or?
Something like that, yeah.
And I know Mr. Batchelor's been 30-plus years. That's quite a service. And I admire him for it.
Well, I sincerely wish we could cause you to reconsider, Mr. Randy, because I do value, it's always good to know when I look over here that there's somebody who's got a good, solid mind, and I mean that sincerely. And I appreciate everything that you've put into this. If we can't talk you out of it, all we can do is wish you best of luck in the next phase of life. But just know that if you ever want to reapply, we will support your decisions. Appreciate you very much, sincerely. Okay. We will move into contractor applications.
Excuse me. Board members, we have one applicant coming before you today, Mr. Gary Gunner. Mr. Gunner, if you will please step forward to the podium, state your name and address for the record, please.
Gary Gunner, 28276 Thunder Road, Robertsdale, Alabama, 36567.
Board members, Mr. Gunner will come before you for application for examination for general contractor. He does come before you with 6 years of experience verified. I apologize. Staff's recommendation is for approval.
Move approval.
Second.
Do you have any questions? You ready to move over into Florida and work, huh?
Yes, sir. So I was born and raised in Florida, and then got married. My wife and I moved to Alabama. But I work in Pensacola, so and have for years.
Gulf Atlantic.
Yes, sir. Then I also own another business. I do like dump truck work and stuff like that. So, and it's always been out of Pensacola.
Anybody have any questions? Any input? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, you've been approved to go for the general contractor's license.
Thank
Good
you.
luck, Koya.
Yes, sir.
Yes,
Thank
sir. Now we'll move into our disciplinary hearing process.
Yes, sir, Mr. Chairman. Our first item today is Mark P. Nunes doing business as Creekwood Builders LLC, state registered license number RR 282812147. Contractor Competency Board complaint number 240434COM. It's in regard to Charles Day, the homeowner complainant at 1202 East Gadsden Street, Pensacola, Florida 32501. This is in the city limits. Proper notice was sent to the respondent. Mr. Day, are you present? Let the record reflect that Mr. Day is not present. And Mr. Nunes, are you present? Again, Mr. Nunes is not present. Staff would request that the backup documentation and testimony provided at the probable cause hearing be moved into evidence.
So moved.
Have a second? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion's approved to move evidence into record.
And at this time, I'm going to have our investigator, Ms. Reber, sworn in, and she will remain sworn for the duration of this hearing.
You swear affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
And Ms. Reber, did we receive any additional documentation in regard to this case after that probable cause hearing?
Just an update from Mr. Day. He doesn't reside here. He's in Nevada, and that is part of your backup. And it's an update on how much money he's been returned.
Staff would request that that additional documentation also be moved into evidence.
So moved.
Second? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, additional evidence is moved into record.
And Ms. Reber, can you give us a brief rundown of that additional payments that you were just speaking about? An update?
Is it up there? Can you open that? It's just, should just be an email. Right at the end. Is that the last one? I'm sorry, I can't see from here. I apologize.
I think it's that one.
Yes.
So what you're seeing on your screen is the update that I was referencing. Mr. Day states that Mr. Nunes had refunded $10,000 on April 9th of the $42,079.69. He would like to request restitution in this case in the amount of $32,079.69. At this time, I'm going to bring up the administrative complaint. After the probable cause, at the probable cause hearing, the board determined that there was probable cause to believe that the respondent violated County Code Section 1837D8 for mismanagement or misconduct causing financial harm to the customer. The board cited that the respondent violated this code section by receiving funds for the project and permits, agreeing to refund the monies paid, and failing to refund those monies. Also, County Code Section 1837D10 for abandonment, for failing to perform any additional work on the project after the completion of the interior demolition. And Code Section 1837D15C, job finished without a permit having been pulled, or no permit until caught after job, or late permit during the job resulting in missed inspection or inspections. And this, the board cited that the respondent failed to obtain the required permitting. So at this time, with no other parties present, it's up to the board to make a determination on each count.
Including restitution would be in the option if it was chosen to do that, correct?
That's correct. That would come later in our process, but yes.
I'm just making sure everybody's aware that would be a option to what we're looking at.
And
Okay.
this is first violation?
So count one was Code Section 1837D8, mismanagement or misconduct causing financial harm to the customer.
Do we have a motion or discussion on this?
I'll make a motion to find him in violation as to count one and fine of $1,500.
I'll second that.
Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion's been approved.
Count two, Code Section 1837D10, abandonment.
I move that we find him in violation as to count two and a fine of $2,000.
I'll second that.
Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion is approved for count two.
Code Section count three, Code Section 1837D15C, job finished without having a permit been pulled, or no permit until caught after job, or late permit during the job resulting in missed inspection or inspections.
I'll find him in violation as to count three and a fine of $250.
I'll second that also.
Motion is second. Any discussion? All in favor, raise your right hand. All opposed, same sign. See none, hear none. Motion is approved.
Our next item would be, there has been a request for restitution in this case, and it would be up to the board to make a determination on that request.
Do you have a motion for anybody concerning the restitution amount that is being sought, $32,079.69? That's based on the previous 42 minus the 10,000 payment that was made in April.
I'll make a motion for the restitution of the 32,000, thank you.
$79.
$79.69, thank you.
I'll second it.
Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion is approved. Restitution sought of $32,079.69.
And our last item for this case would be a recommendation to the Construction Industry Licensing Board in regard to the respondent's registration.
Do you have a motion? It can be no further action, fine, suspension, revocation, or restrictions on registration.
I make a motion for revocation of his license.
Do you have a second on revoking of his license?
I'll make a second.
Any discussion?
Do you have any open permits from him?
We can ask staff.
Do you have
to-
anything open on him?
I would have to pull his license real quick if you'd like. Okay.
He's not made it to any of these meetings, has he?
He has not been in attendance at any of these meetings, no, sir. So what you see on our screen is our permitting software, which houses our licensing cards for all contractors, either licensed or registered in Escambia County. I'm just typing in his name into the search. And here you can see this is the licensing card for Mr. Nunez. Under the Associated Permit tab, there is a permit that was pulled in 2023 that still has a permit issued status. He has not pulled many permits in Escambia County. You can see the complete history as those few that are on your screen. Looks like 1, 2, 3, 4 that are still open, but we would have to go into each one and see as to why they're still open.
So is there any other discussion? Anybody having comments on these? There's a motion on the floor, so we need to. Any other input? We'll take a vote. All in favor for the revoking of the license, raise your right hand. All opposed, same sign. Seeing none, hear none, motion is approved. To recommend for revoking.
Thank you, sir. Our next item is Wade L. Hunter III, doing business as Lee Hunter Construction, LLC, state registered license number RR 282812171, Contractor Competency Board complaint number 240749 COM. It's in regard to Charles Thomas. The homeowner complained at 622 Air Street, Molino, Florida 32577. Proper notice was sent to the respondent. Mr. Thomas, are you present today? Let the record reflect that Mr. Thomas is not present. Mr. Hunter, are you present today? I am. And are you going to be providing testimony in regard to this case? I am. Thank you. At this time, I'm going to have Mr. Hunter sworn in.
I do.
Thank you. Staff would request that the backup documentation and testimony provided at the probable cause hearing be moved into evidence.
So moved.
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion approved to move evidence into the record.
And Ms. Reber, did we receive any additional documentation for this case after that probable cause hearing?
The only additional information I have is that this permit had expired after the last hearing. Mr. Hunter has reinstated that permit.
So since there is no additional documentation, we don't need to move anything extra into
Additional.
evidence. Yeah. Mr. Hunter, this is your opportunity to speak in regard to this case. You received your administrative complaint that detailed possible violations against your license. I'm actually bringing that up on the screen for you as well. At the probable cause hearing, the board determined that there was probable cause to believe that you potentially violated Code Section 1837 C11 and Code Section 1837 D9D. 1837 C11 provides that a code violation results from finding that a contractor is guilty of fraud or deceit or gross negligence, incompetency, or misconduct in the practice of contracting. They cited that you were using inadequate equipment for the tree removal, resulting in additional damages, leaving the structure open to the elements, resulted in additional damages, and failing to obtain the required permitting and failing to obtain inspections. And then the next code section is 1837 D9D, which is contracting beyond the scope of license. A safety hazard is created. They cited that you were performing electrical work without having the required license. Again, this is your opportunity to address the board in regard to those proposed violations.
This started as a insurance job with a big tree that had fell onto the house. I heard that, excuse me, Mr. Thomas said that the insurance paid for a crane, but that was not true. We used a tractor to take the tree down. What had happened was there was about 26 trusses that were broken because of the tree fall. They were actually 2x8 stick frame. They weren't engineered trusses. So what we did was we scrapped the deck, got all the way back down, and reframed it stick frame how it was, redecked it, and re-roofed it so no more water could get into the house. The majority of the damage, other than the main house, was the garage was crushed. The exterior walls were crushed from the tree, which was reframed and dried in. A vapor barrier put on the exterior. The roof was put back in. The garage trusses were engineered trusses that came from a engineered plant. They were put on. The drywall's still down. It can still be inspected. The plans are not ready yet to get the proper permit. But the stick framed, like I said, the stick frame can be inspected through the attic. We did stick frame it back together, and we did put the roof back on it so the water didn't continue to leak in while we were waiting. But all that's left, like I said, this is an insurance job. There's about $55,000 owed for about 2 weeks worth of work. The only remaining items left to finish the job is put 2 windows in, put the siding on the garage, a little knee wall that was there, and once the inspection happens, finished a little bit of drywall in the garage, and job is complete. With $55,000 being owed on the job, trying to get the insurance company to pay another draw so we can continue is why this job is stalled. Actually, it's $53,000, I'm sorry, not 55.
Board have any questions? Count one.
Open question. Did we hear this information in probable cause?
Yes.
The same information?
Well, we didn't hear from,
I-
Mr. Hunter is not, this is his first time before us.
Yeah, I missed.
That's what I thought.
I apologize. I missed the probable cause. Me and my business partner are not living at the same address, so I've had to do a change of address, which has been updated. So I was not aware of the first hearing.
So the count one is by a violation of the code by using inadequate equipment for the tree removal resulting in additional damages, leaving the structure open to the elements resulting in additional damages, failing to obtain required permitting, and failing to obtain inspections. Did you have the proper permit in place when you were starting this?
As removing a tree or to reframe. I started with a residential or a alteration permit. I did not get the permit for, I guess, putting the trusses back on.
But you did the work without a permit?
Correct. Yeah, we reframed without a, I guess it'd be a framing permit. But like I said, everything's still open. It's still be inspected. It's not like we closed everything up.
I understand that, but do you understand that you're not supposed to do that until you get a permit?
Yes,
That's
sir.
why this is here.
Right.
Is because it was not supposed to happen until the permit was in place.
Right, yeah. Yes, sir.
Okay. That's the reason for the count one, uh-huh. And of course, if there's no permit, there's no inspections, which would follow suit, Any other discussion? Do you have a motion? Count one.
I'll make a motion to find in violation of count one. Escambia County Code Section 18-37, C11.
And what type of fine, or any?
Is there a fine associated with it?
13.
Okay, and a minimum fine of $100.
I'll second it.
Okay, I have a motion and a second to fine in violation of section 18-37C11 with a $100 fine. Any discussion on this? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion is approved. And count two.
Would you like for me to read it?
Please.
I
I'm
can.
waiting on you.
Code Section 1837 D9D, contracting beyond the scope of license, a safety hazard is created. Mr. Hunter, if you'd like to address that.
Yeah, I took a electrical light fixture off the side of the garage, and I did push a new wire down that wall. And there was some other new wires that were cut, or there were some old wires that were cut when we slid the new trusses. Excuse me, when we slid the new trusses on, the wires were hanging, and I did kind of pull them back to their spot. Nothing was connected. It was just stapled off, and nothing's connected. Nothing's put on a breaker. Can't turn no power on. It's just waiting for the electrician to go double check everything, get everything inspected, and then he can turn the power on. So, you know, wires run through the trusses. Unfortunately, we had to take the trusses off, slide new trusses in, the wires got cut. All I did was put them back, staple them back, and that was it. Nothing's been connected, nothing. You go turn a breaker on, nothing's gonna come on. Nothing's connected to anything. It's just sitting there. Nothing, you can't turn nothing hot.
Question. Mr. Hunter, do you have an electrical contractor that's assigned to this project?
I do.
Thank you.
Did the electrical contractor pull a permit, or did?
No, there's no permits pulled yet, because I'm still trying to get another draw. So he is assigned, I mean, he is gonna finish the job, but I'm trying to get another draw from the insurance company to pay.
So has he done any work on this? Maybe.
No,
we
he
shouldn't
hasn't.
ask that question.
No, he hasn't started anything. Like, no, he has not. The joints haven't been made up or nothing.
The only thing done electrically is you re-pulled wires.
Correct. That's it.
And that's all.
That's it. And I took a light fixture, didn't have no power on it, off the side of the garage. That was it. No power, no outlets put back in, no switches, nothing like that.
I guess the determination would be, is that something that he would be qualified to do without an electrical license? And I don't know if Mr. Tim or Mr. John could answer that for us. Mr. John, is that something he can do without a license?
If he just pulled the wire out, excuse me, for the truss repair,
Right.
then he could probably put it back. That would be no problem. But you were saying that the wires were cut. So what happened after that?
So there's a junction box, and it was just pulled back to its dedicated spot, but not hooked up. So, and there's probably, I don't have the pictures with me, but there's probably 2 or 3 junction boxes where were cut and going to be spliced back together. Like I said, they're still in the box. They haven't been touched.
I would say that would be incidental to his work.
Who installed the junction boxes? Were they there existing, or is this something new?
No, it's just a box hanging from the ceiling.
Who put the box there?
I did. Yeah, but it's not, like I said, it's not connected. Nothing's been wired. No wire nuts are put on nothing.
It's a fine line of something maybe.
Yes, sir, as long as he didn't make the connections and a licensed contractor does that, I think it still would be incidental to his
Still be,
work.
okay.
Yes, sir.
Did that answer questions for everybody? Okay, do I have a motion or any decision on count number 2 here?
So staff is saying, correct me if I'm wrong, that what he did was not in violation of any codes that we have?
Electrical code, yeah.
Okay. And I'm not quite sure if I made this motion to move forward with this violation,
So
on
as
the
you
last
recall,
meeting.
during the probable cause hearing, Mr. Hunter was not present. So this is new information we're receiving today. Your decision was based on the testimony provided from Mr. Thomas, who was present at the last hearing and provided a few videos.
There's a video.
That were shown to the board. So again, this is new information that's being received because Mr. Hunter is present today.
In the video, we just saw him actually pulling wires, working with
Pulling
wires,
wires.
and then,
Nothing's been connected, yeah, just pull.
So then, I'll make a motion to find, not in violation of count 2.
okay. I have a motion and a second. Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion for non-violation of count 2 is passed.
I need a determination on a time frame in which the fine for account 1 needs to be paid.
30 days.
All right, I have a motion and a second for count 1, the 30-day for the payment of a $100 fine. All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion is approved.
Who do I pay that to? Just like a permit tech or?
It'll be detailed in your final order, but it would be to Escambia County. Yeah.
Perfect.
I don't have any documentation in regard to a request for restitution, so we'll skip over that part. And the last item is a recommendation to the CILB.
So at this time, I'll make a recommendation not to send it to the,
Well, so we have to share our findings with the Construction Industry Licensing Board.
No further
but with
action.
no further action to be
Thank
taken.
you.
All right, I have a motion for no further action to the CILB. Any second? Second. I have a motion and a second for no further action to the CILB. All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion is approved for no further action. There is another area here, not that we need to respond to it, but there's other penalties of denial, suspension, revoking of obtaining permits, limited permits, et cetera. But is there any appetite for that? I don't sense anything for that, so, okay.
And that's it for this hearing. You will receive a final order, and again, it'll detail all of this within that final order.
Thank you.
Thank you.
Thank you, Ms. Turner.
Board, I need to circle back to the previous case on Mr. Nunez doing business as Creekwood Builders LLC. You assessed fines and restitution in that case, but we did not give any time periods. So if we can take them one by one, I need a time period for the fines to be paid.
Do I have a motion for count 1?
The fines totaled $3,750.
Do we need to go count by count, though, or just
No, sir, it's a
batch them into one?
time frame in which all fines
All
have to be
fines,
paid.
okay, I apologize. So, do I have a motion for the time frame for all 3 counts fined to be paid?
Make a motion for 90 days.
Okay, 90 days?
Second.
I have a motion and a second for 90 days for the fines to be paid. All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion is approved.
And then you also determined that restitution amount, I need a time frame in which that has to be paid.
We have restitution of $32,079.69. Do we have a time frame?
I'll make a motion, we stay with the 90 days on making restitution.
90 days. Do I have a second? I have a motion and a second. All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. 90 days restitution time frame has passed.
Thank you. So our next item is a reconsideration of a final order hearing. This item is Christopher W. Brown, doing business as Shooting Stars Construction LLC, state registered license number RG 0019314. Contractor Competency Board complaint number 230557 COM. It's in regard to Vin Cal, the homeowner complainant at 3709 Idlewood Drive, Pensacola, Florida 32505. Proper notice was sent to the respondent and the complainant. This, again, is a reconsideration hearing of the final order that was previously entered. I'll bring up the final order and just remind the board on what was ordered at that time. So the respondent had to pay fines in the amount of $2,500, and that has been done. Restitution was at that time ordered in the amount of $240,161.31. It was supposed to have been paid within 180 days of this final order. This final order was entered into November 15th of 2023. Subsequently, Mr. Brown came back to the board and there was some discussion about that restitution amount, and Mr. Cowell agreed that maybe that was not the correct restitution amount. Subsequently, that restitution amount was dropped to $188,251.18. This is the notice of suspension of Mr. Brown's permitting privileges, because the board determined that should he not pay that restitution within that time frame, then his permitting privileges would be suspended. At this time, they are suspended and will remain suspended per this order until that restitution is paid in full. At our last hearing, Mr. Perez came back on behalf of Mr. Brown to public forum and requested that those permitting privileges be reinstated. He stated during that public forum appearance that there were some payments made toward that restitution, and he requested a hearing, and that is why we're here today. The board directed us to have a hearing in regard to that prior decision. I believe that Mr. Brown is present today, and Mr. Perez is also present in regard to this hearing, and I see that Mr. Van Cal they're all in the audience. Are all of you going to speak in regard to this? I'm going to have all three of you sworn in, okay? Mr. Perez, Mr. Brown, this was your request for a rehearing, so if you'd like to come and address the board in regard to your request.
My name is Mr. Perez, 4912 Suffolkville Road. We come here in compliance with the board. We have paid restitution in the amount of almost $20,000 at this moment, and we would like to have a license reinstated so we have the ability to keep paying every month what the contract is made with Mr. Kyle and the lawyer, which is a reminder of another $5,000 next month and another $5,000 the month after, and after that it will be $3,000 a month until the final payment is done. I have the receipts here.
So you've paid $20,000 to date, is that correct?
Yeah, it's the amount of $20,000 that we pay in 2 months.
The balance is at $168,251.54. So there's supposed to be another payment of $5,000.
next month. We
This
already
is
paid
September.
one.
This is September now.
So what we have. Sorry, I apologize. So what we have, that Mr. Perez just provided is proof of 3 payments made to Mr. Cal. No, 2 payments.
3 payments.
Oh, that's the previous. So he did make a payment on September 3rd. So,
5,000?
yes, that's correct.
That was what was supposed to be paid.
That is correct.
Do you want that moved into evidence?
Yes, that would need to be moved into evidence.
We'll have to get a copy for the board. This looks like his originals. Is this your original copy?
Those
Are
are
you
the
ori-
original.
The originals? Okay.
I can make copies and give it to them.
That's all right. We can send somebody to go make copies.
All right, no
All right.
problem.
Do I have a motion to move the submitted evidence into record?
So moved.
Do I have a second? I have a motion and a second to submit the new evidence into the record. All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved. And we get copies made for everybody. So with the new 5,000 down, now it's 163, 251, 18.
That's correct.
I don't know if you guys have the agreement that we have with the lawyer, Mr. Kyle, about the payments, which is in record. You can probably bring it up so you can see it, and we have been complying with everything they say, and even Mr. Kyle's agreement that we should have the ability to keep working in order to keep paying.
I don't think we have a copy of the
We do.
on record.
I can bring that up.
Oh, okay, I didn't see it in the.
It was previously
I
submitted.
got you,
Mhm.
okay, okay.
Mr. Chairman, I'd like to hear from Mr. Tao, too.
Mr. Cal.
Yeah, Get it.
I was thinking the
moment.
same thing.
Thank you.
Another reason why you should stay. He can't wait for this meeting to get over, can he? Thank you, Mr. Perez. Any other statement you'd like to make to us?
No, sir.
Okay.
Just waiting.
Thank you all for making these payments. It does mean a lot from us sitting here with somebody
sir.
compliant, so thank you.
No
Thank you.
problem.
Mr. Cal, would you like to address the board?
Good morning. Vin Cal at 1743 Caesar Lane in Pensacola, 32514. First of all, I just want to say thank you. Thank you so much. I know it's a long road for us and for all of you too. We can listen to us and complain. All you can hear is complaining. You don't hear anything good out of it. To make it worth it for everyone else, and I'm here, and then I would agree with that. Whatever the board make a decision, that's beyond me. I already done my job, so this everything now is a plus. And God bless, and thank you so much. And the board recommendation, whatever it is, work for me. The only thing my primary concern when I asked it with the board is if what happened, he stopped making payment. What do I need to do?
Yeah, I don't think that we have ability to control that from here. That's on the civil side. Is this correct?
So you entered a subsequent order that said that his suspension of permitting privileges would be until the restitution was paid in full.
So would it be appropriate if it's to make it probationary versus suspension? Asking the board.
And what about legally? Can we sidestep into a,
You've already entered your final order. There's been no new development other than making a decision as to whether or not, is that what you want at this? I mean, the question is that what the complainant wants? And you might want to take that into consideration, but your ruling, I mean, your final order, if you start messing with it right now, then you may put yourself in a position that we saw earlier where there is no more, there's no controls. So, but I don't think you can go back after you've already entered your final order and change your final order in a situation where you didn't retain jurisdiction for the purposes of determining later that you wanted to put somebody on probation. You would have started that at the beginning. Is that your question?
Yeah, so are our hands tied from doing anything is what,
No, you could
I'm hearing.
certainly, I think you can modify your order
That's-
to allow him to have some privileges. Your problem is that if he violates it, your hands are tied.
even if we add to the amendment or to the modification, that if he doesn't, it would be suspended again?
are we allowed to do that? That would be a good question, Mr. Miller. Are
That's
we
my
allowed
question.
to?
Can we-
And there's not a lot of clear guidance on
Right.
this. My recommendation would be, so then I'd have to look at it from the appellate standpoint. So then that starts the appellate clock all over again. He can appeal again to the board, he can appeal again to the circuit court and come, and go after your order. Even though he agreed to it, he could still appeal it. Maybe, what are you trying to do? What is it you want to do? Maybe
Well-
that's an easier way for me to answer the question.
Well, right now, he's suspended and can't do any work. So if it was up to the board and agreeable with the parties to allow him to work to earn money to pay them back, could we allow him to pull permits until unless he violates the order? Or if he violates this, is it a court order that he's under right now to make that payment that's been modified?
There may have been a civil settlement involved, but currently, the only thing that you want to be looking at is whether or not even if there's a court order, a civil court order, it's not going to have, it has some enforcement power, but you're two different enforcement powers.
Right,
Yeah.
but in the last conversation we had, it was if there's a violation of a civil order, it could be something that would come to the board by violating a civil order?
A civil judgment.
A civil judgment.
Right, and that's two different things. You get an order to pay, and then if you don't, then you have to come back and get the judgment, is the way I understand it, for failure to
Okay.
pay. So it's another step in the process. But I think Jennifer was looking it up. I think he has pending permits that are open, so he was able to finish those permits. Does he have any open?
That is correct. There are some that are open, still under his license, and the board did say that they were going to allow him to finish any open projects.
And you can correct my math, but it looks like there's 15 open permits issued.
There were quite a few. I'd have to count really quick, because we have to go.
So the key would be if there is some leeway to allow permitting privileges and he did not follow through with this, is there a way to make it immediate? Take away the permitting privileges immediately from that, or? If not, then we need to take a full picture look.
So Jennifer, I think, counted up 12, so
Yes.
close to the 15 number. That one of them happens to be Twin Oaks Villas, which is an apartment complex that he has, that has multiple permits open.
So if I'm reading this right from the legal area, if we grant privileges and he quits making payments, there's nothing we can do to put a bite back into it.
I'm going to take a look at your final order again and see to what extent you retain jurisdiction.
So there is the notice of suspension of permitting privileges.
Right, okay, so looking at that one, that shows that he already had not complied with your first order. And then so a second order had to be entered for his failure to comply with your first order. So at this point, we would be basically three orders out. We're gonna, I don't think you have jurisdiction anymore.
That's
I
what
think that looking at it, in my opinion, I don't think you have jurisdiction to modify those orders. And that may not be what your board wants to do anyway.
It may not be,
We may
but
be out ahead of that question.
but I'd like to at least know the,
I know this did affect, I think there was a contract he was entering into. So I know that his failure, based on public record, his failure to have his permitting privileges or come in before this board did affect a contract that he was trying to enter with the county. So I don't know, I can tell you from public record, we know that it did affect one contract.
well, we were not, that was not a part of our decision making at that point because we were
It
not.
was not.
So what's the board's consensus feeling on this then? Is there any reconsideration or?
My motion is no reconsideration.
Okay, I have a motion on the floor for no reconsideration of the final order hearing.
I'll make a second.
And I have a second. I have a motion and a second for no reconsideration of the final order hearing. Any discussion? Okay, ready for a vote? All in favor of no reconsideration, raise your right hand. I'm sorry, look on this side. Can we do this again? Okay, and all in favor of or opposed to that? We have one. Okay. Motion is approved for no reconsideration of the final order hearing.
Our last item for today.
Thank you, Mr. Cow.
Oh, thank you.
Thank you.
Yep.
Thank you. Our last item for today is a sunshine law presentation and discussion from Christie.
Can I make a suggestion? If we're going to have potentially new members next meeting, would we redo it then, or should we?
So it's required to be done in the September meeting.
Okay.
I think we can probably, if we have potential new members, we can get them their own presentation and
Okay.
discussion with Christie
Thank
as a
you.
side, on the side. Mhm.
Is this required for all current board members to be?
Yeah, Randy can go. Randy's other problem is, he can't. He's got other. You still have to follow the ethics.
Thank you again, Mr. Randy.
Bye-bye, thank you. Should I get his plaque?
Give it to him.
Okay.
You'll give it to him?
Do you want to save it?
We have to save it.
Mr. Randy, would you like to have your name tag? We are suspending the sunshine law for Mr. Talbert to make comments. Mr. Oglesby, will you please stay in the room?
I did, yeah. I wanted to tell Randy how much I appreciate it. I recruited him at the worst time you could be on this board.
Yeah.
And y'all remember.
I do.
And he stuck with it, and I think he lost some customers even. So I appreciate what all he's done. He was a big part of that. So
Very much.
I appreciate that.
Yes, sir. And I really wish that you would reconsider again before you walk out that door. Thank you, Mr. Randy. Thank you for your service.
And by the way, Mr. Patel, you don't have 3 years in because you came in and replaced our former plumber, right? That wasn't, so that's been less than two, that's just been a little bit over.
It's been a couple years.
Just
Yeah.
seems like a long time when you're.
I remember,
Right.
that was Banks Lacoste World.
Yes.
That's when all that was going on, so it
Mr.
hasn't been
Irwin's
that long.
been here about 10 years.
Yeah.
10 years. He's been here a while. Oglesby? Yeah, he was here a while. Okay, so you're required to do a sunshine law presentation. I'm required to do a sunshine law presentation. You're required to listen. So that's what we were talking about. And I think we have it in our policies that we do it every September. Has everyone seen this before? I can't remember. Okay, all right. So hopefully it'll be interesting to at least two people. So the Sunshine Law, there's two parts in Florida that we follow as a government. One of them is the Sunshine Law, and the other one is the Public Records Law. The Sunshine Law deals with our meetings. Public Records Law, of course, deals with any document that's brought in. And document is very wide open. It's a recording, a piece of paper, a note, anything digital. It's a very wide open. But it has to be but there are requirements when we're talking about public records. And not everything that's taken in is considered a public record. Just because it came into our office doesn't make it a public record. Writing down a note that says so-and-so called is not necessarily a public record. But we won't get into public records because that book grows every year. Sunshine Law is pretty well set in stone. Now there are just the occasional decisions that are made by the courts. So what you have before you is the Pork Chop Gang. So that's all North Florida senators, and they basically ran the state for many years. In fact, they really didn't lose their power until the 1970s. So probably till 1977, I think, was about the time that they were wrestled out of power by other people in their own parties. All Democrats. Republicans were not very popular in Florida for many years. And first time Republicans started to come into power was in the 1960s. But as far as the governorship, until Jeb Bush, there was two Democrat turned Republican governors. And Jeb Bush started the run of the current Republican Party within our governorship. But the Pork Chop Gang had all the power in the state of Florida. Sorry, was I taking too long, Jennifer?
No, I didn't. I don't know when you want me to turn this thing.
Let me just move on.
I'm waiting for that cue.
The Pork Chop Gang basically had all the power in the state of Florida because the way that the Florida was designed, was laid out, was district. The southern, more popular states in the state, cities in the state of Florida didn't have as much representation as the northern region. So the northern region ran everything. The Pork Chop Gang, the joke about it was, we don't know if it was because of the pork they put in their bills or the way they wore their hair or what they ate. So no one has ever figured that part out, but there's been a lot of jokes about it. So what happened with that is there was a lot of meetings that were occurring outside the public eye between these people that were in our legislature, and they were making deals outside of the public eye. One of those deals dealt with the interstate that was going south. There was an interstate committee that had been put together, and they were regularly meeting outside of the public eye with investors and telling their friends which property to buy and where that interstate was going to run, so that they could make a lot of money when they sold it back to the government and able to put the interstate through it. So that was one of the deals, and Red Cross was one of the state legislators, and that's why his picture's up there. So then, aside from that, there was also other things that were it was just happening all the time, that things were being done outside of the public eye. These deals were being made over poker games or on fishing trips or whoever was pushing for an advantage without the public knowing. At that point, we did have public records requirements. We did have Sunshine Law requirements, but the Sunshine Law requirements had been interpreted to mean that that's whenever the whole board meets together outside of the public eye. But two people on the board could meet, or they could be influenced. So what you have in front of you is part of one of the things is the Form 8, which is part of our ethics requirement, because you have to disclose whether or not you're being influenced from the outside, or you have a financial interest, or your family has a financial interest. There's also a requirement of disclosure on bias, and that's what we were talking about earlier. I was trying to make sure that what was being put in front of you wasn't you cannot consider it when we do a hearing. You have to go from the facts that are presented during that hearing. And as I recall, we don't swear in public forum guests. So in that situation, you don't have any sworn testimony in front of you anyway, but I was trying to get out ahead of that. So Emory Red Cross, he chose the nickname because he knew people would remember it. He was quite a powerful figure in the state, not Escambia. We had W.D. Childers. So Emory Red Cross, he was a prosecutor, he was a representative, he was a senator, and he was a judge. That was his careers within the state of Florida. But while he was within the legislature, he was the one that started pushing he started pushing the law, the Sunshine Law, and feeling that all these things should be out in public because he knew what was going on. One of the things that had gone on prior to him taking office was, you can go to the next screen. I think you have a different presentation than I do. So let me tell you, I've updated this presentation. It's not there. So if I had the current presentation, that's my fault because I know she asked and I thought I'd already sent it out. So John Pennekamp, if you've heard of Pennekamp Coral Reef down in the Keys, John Pennekamp was a Miami Herald editor. And John Pennekamp got into a poker game with some senators back in 1947. This is back when they were trying to preserve the Everglades. And in that poker game, it was being held at an FPL fishing camp and over at Horseshoe Lake down in Marion County. And that day, Pennekamp was a big environmentalist, and he wanted to preserve the Everglades. The federal government wanted to preserve the Everglades, and it had become, Marjorie Stoneman Douglas had written the book, Rivers of Grass. If you haven't heard of Marjorie Stone, I mean, I know you've all heard her name because of the horrible shooting that occurred at the high school that was named after her. However, she was very influential in the state of Florida and very influential in women's rights to vote. So people don't know enough about her. So I always like to drop her name into this, or it's a new thing for me to drop her name into this because I want people to understand she did great things and that it shouldn't always just be a horrible memory of what happened at that school. So the Everglades, the story about the Everglades, so she was part of the group that was trying to get the Everglades protected. But John Pennekamp is at this poker game. He gets invited to it by the vice president of FPL, because FPL is also involved in wanting to get the preservation of the Everglades. And while he's at that game, he has a poker game that he's never had. He could not be beat. He was just taking money from these senators' hands, from these representatives and legislatures, hand over fist. And finally, Bill Pierce of East Palatka, he was a senator, he finally says he'd had enough and he wanted to know, how much money do you need to buy your Everglades? And so he told him how much he needed. He said, then how about you come over to the House, how about you come over to Congress and we'll give you that money and you can quit taking it out of our pockets. And that was all he needed. So he shows up, they give him the money he needs, and the Everglades are now preserved. So it was all part of getting it into the hands of the federal government to protect it. So that was one of the side deals, and that was back in 1947. So side deals had been going on for a while by the time that Red Cross comes along in 1967 and finally gets the government in the Sunshine State passed. But it took some other things that had to happen. In the 1960s, there was a census that came out that showed that we didn't have the proper representation for South Florida, and all this control was still in the hands of the people that were in North Florida, the pork chop gang. That census that was done in 1960s led to the United States Supreme Court repeatedly requiring redistricting maps to be developed. And finally, in 1966, that's when we started seeing the structure of our legislature change. That's when that's when Kirk was elected as a Democrat who had become Republican. He was elected into the governorship. It it wouldn't be another government, Republican for a while. But that's when Kirk got elected. So you saw this shift in the powers that be within our legislature. And that's how Red Cross got that passed, the government in the Sunshine State. He was laughed at a lot before that ever happened. And for historians, it came out of a journalism club at the University of Florida who had been pushing this public record and government in the Sunshine State. Florida is unique. Florida is unique. You can see that we had a 1909 public records law. In 1967 is where the government in the Sunshine Law, and it was so important to the state citizens of the state of Florida that in 1992 we put it into our Constitution. The public records law has gone through lots of transitions, has gotten very, very broad, very open, and has kind of, and you think it's shrinking back, but it's still expanding. That book gets wider and wider. And the reason, it is, I should say, the area of law you think would be is shrinking because fewer things are public records. More exemptions are coming out. Those exemptions involve basically the safety of the officials. So your law enforcement officers, your DCF workers, it's more about safety. That's when you'll see those public records shrink to protect the home addresses, the children, the wives, the spouses, wherever they're located, to protect them from disgruntled people or people that are suffering from issues where they might want to take out violence against those individuals. Public defenders, their addresses, judges, those types of things are protected. Currently, I think the governor's plane is protected, where it travels is protected. So for government and the Sunshine Law, the meetings have to be open to the public. There has to be reasonable notice, and the minutes must be taken and promptly recorded. So when we go through our agenda, there's a reason why it's laid out the way it is. So you see that there's a determination of quorum, because of course for any quasi-judicial organization, there has to be a quorum. But then there's also, or else you can't make any decisions. So there's a proof of publication. So that's your reasonable notice. So that notice has gone out to the public. That's why she talks about that. There's a reason why that's on here. It's the reasonable notice. And then also the minutes must be taken and promptly recorded. So even though that so promptly recorded, we've got someone actually taking the actual minutes, the verbatim minutes, and that's what we use. So we have that amount of time until we get that transcript and so that we can get those out to the public. But even if you had not approved them yet, they could still be released to the public if they requested them. We're one of those boards that has a very extensive minute review. Other boards, it's just a jot down of what happened. So, but because you're quasi-judicial, it should be. And then open to the public, which that's obvious. I think that goes without saying. So then the next thing you have there should be how that's defined. You can roll. That's the reasonable notice, the minutes, and then this reasonable opportunity to be heard. That's your public forum. What you can do in public forum, and I don't think we have it, you can limit how many minutes the public forum is open for each speaker. I'm sure you're aware that the Board of County Commissioners limits it to 3 minutes. So, yeah, I'm not really sure why we don't have that. That's what I was talking to Jennifer about, because
Is it in our records?
Well, it used to be when we opened the meeting, nothing related to the agenda items for the day, I believe, and limited to 3 minutes.
So within the instructions that I would typically read at the beginning, it says all parties will be given uniform maximum time to speak of an issue, 3 to 5 minutes. It's not relative really to public forum. However, on our speaker form, it does say that they'll be given 3 to 5 minutes. So it is out there. It's not timed, is what I'm going to tell you. We don't time them and stop them.
We'll figure out a way to get a little timer. That's right. Your time is up.
So also part of that notice requirement, not only does the public have notice, but the affected parties in a quasi judicial hearing would have to have notice. And that's one of those things that she also talks about, that notice was sent, certified mail, that type of thing. So notice is also given. Then at the hearings, they're very, as you are aware, that when you do your hearings, they're very informal. There's no actual evidence laws, but we try to follow them closely, at least to have the board accept all the records, have everyone sworn in, those types of items. Those are more important. You may have heard about it, but you weren't here for it. Those were very important when we were handling the banks on the cost cases, or any case that appears that it may turn out to be criminal, because it's important for the state attorney's office. They have to have sworn testimony for the purposes of filing the charging documents. So by us taking that in, if it becomes something that needs to be taken criminal, we've taken out that step for them. And then the decision that you give has to be a written decision. That's why there's a final order. So there we go. The reasonable opportunity to be heard. We cannot restrict content, which that's where I was, that's where it got a little dangerous today, because while she could talk whatever she wanted, you had to not consider that if it becomes a case before you. What she said today is not a matter of record for your consideration. And if you had a bias, if it caused you to be biased, you'd have to disclose that. Next one. And here, so this is part of the form. So these are the times when the public doesn't, when people don't have the right to be heard. So you've got the emergency affecting public health. So when EOC is activated, we're not putting out public forum announcements that anybody needs to come up there and help us while we're in the middle of handling a hurricane. Ministerial acts, so often, if you've watched the BCC, they have the ceremonial, they have the proclamations where they read the board. And then there's exempt meetings, and then of course, actually during a quasi-judicial, people can't come forward and have anything to say unless they're a related party. That's where related parties are required. So for penalties for violation of now when we have violation of sunshine law, that means that there's a lot of times where that occurs. And the trickiest one is, for us currently, is when it's online. So in social media, you'll have people commenting on their forum, which we previously had someone on the board who was, and he still does. He still records us and puts things out there on his social media, but he regularly would do interviews. He would regularly comment on things. And if it's something that's going to come before the board, we can't keep you from speaking. You can certainly speak. But if you're expressing your opinion as to something that's coming before the board, it's going to present a problem for the board later, because you're going to have to disclose that one as bias. But what if the press comes to Alton Lister and ask him a question, and then they go to you, Melanie, and they ask you the same question and said, well, Alton said this, what do you think? And then you comment in it. Now you've used a third-party person to have a public records, something that should have been in the Sunshine Law, should have been at this board meeting. So you've had a third-party meeting, basically. And we have to watch that with staff, too. You'll notice that whenever you get an email from staff, you get blind copied, so that if you all responded back, no one else sees what the comments were coming back. So we watch it like that as well. Violations are there in front of you. You got a non-criminal infraction. There's no intent there. Criminal is going to involve intent. It can get costly. Second-degree misdemeanor is very low, but it can get costly when you're looking at attorney's fees. So, is that my last one? Okay. Sorry, it's an older one. We'll get the new one over so that you have more information. And I just wanted to make sure you were aware of that 8B. This is the financial interest form. Take the copy with you, read through it, see if you have any questions. It's part of the ethics, and I think you do. Do they have you doing ethics trainings? Do they send them ethics trainings? Okay. If anybody wants to do anything on ethics trainings, I can certainly do. I can see on here, this form is not the one you would fill out because it actually says November 16th of 2021. So this would not be the form you're filling out. We would give you a new one if you said that, hey, I need to disclose this, and then you fill this out. And we would file that. And it doesn't necessarily, if you had a, it doesn't necessarily mean that you can't comment, just means that you can't vote. Okay. Anything else? Any questions? Any comments? Got anything? Okay. Just to make sure, because she's seen it several times, I know. I do it for more than just one board. And I'll get the new one out with the new video, with the new pictures. They're not that fancy. But I'm,
So, Christie, I will say, I've sat with this board for a hot minute, and used to Sunshine Law presentations where.
we can,
But you spice it up.
okay. I just want to make sure we weren't insulting my other coworkers.
No, I mean, you bring added insight into why, right? Which is nice.
Well, there's a lot out there in Sunshine Law, and we could certainly read through the Sunshine Law, and you would get it. But understanding I appreciate that. I find it can be very dull material if you're not careful. Thank you.
Thank you, Ms. Christie. Thank you for what you do for us, too, as a board, keeping us straight the best you can.
I appreciate that a lot of times there's questions I just don't know the answer to.
Yeah. We're
That's a lot of fun.
appreciative you're
for me.
here. Before we adjourn, Mr. Randy has decided not to be a part of this anymore, but I just want to thank everybody else. Just take this one little moment. I know Mr. Bill, Mr. Batchelor, Mr. Irwin, you guys are long-termers here, and there's a lot of input value that us that hadn't been on there as long can appreciate that, and so I want to make sure y'all know that, and hopefully everybody else will stay with us. I know there's a thing where the board makes the decision, but I'm proud of everybody that's been here with us, so just wanted to make sure everybody knew that. Meeting is adjourned.
Appreciate you.